You're listening to God, Law, and Liberty with David Fowler and Gary Humble. We're putting culture on a collision course with the truth.
Welcome to another episode of God, Law, and Liberty. I'm Gary.
And I'm David.
And what we're going to talk about today, we are certainly no strangers to talking about here on the show, is sort of the difference between court opinions and court judgments. We talked about that from several different facets, and sort of how laws are made. But the issue of how opinions, number one, do affect how we interpret law and how we approach different cases, but also how sometimes lawyers and judges and people in general tend to treat court opinions almost as law, which of course we believe to be pretty big error. Am I right?
Mm-hmm.
Just checking.
Yeah, that's right. That's right.
And of course today in Tennessee we're going to find ourselves in another situation where this is really important, because we're going to have to defend our abortion law that recently passed in court, because of course about 45 minutes, as we knew, after the governor signed the bill into law, it was enjoined by the district court. I guess his lawsuit by, was it Planned Parenthood and ACLU and all those folks. So so it's important how we go about this defense. And so I'll let you begin to speak a little bit into that. But I think it's just, gosh, it's so critical that we understand, maybe hopefully make that clearer for some folks today, the real difference between the function of an opinion and the function of a judgment between in a case or controversy. Right.
Yeah, it really is important. And we want to discuss this issue in the context of the decision from Monday, where the federal district judge, William Chip Campbell, entered a temporary restraining order against the state to prevent it from enforcing the new Tennessee abortion legislation. Now, there'll be a preliminary injunction hearing, which is a different kind of hearing, on July the 24th, I believe it is. So for one thing, for people to understand, a temporary restraining order is what a judge enters, usually without any hearing and arguments by the parties, though in this case there was a brief by the state. I don't know if they had oral argument, but in any event, it says, I'm going to temporarily restrain this law, maintain the status quo until we can have a more full and complete hearing, which would be the preliminary injunction hearing. So a temporary restraining order can only last for so many days. Then you can enter a preliminary injunction that can continue in place during the trial and motions for summary judgment and all of that. And then the court can make its final decision. And when it makes a final decision, if it finds the law unconstitutional, it enters a final order enjoining the enforcement of the law. So we're at the first of three potential stages here. The temporary restraining order, we lost there. Now we're going to have a hearing on a preliminary injunction, which would continue to enjoin or prohibit the enforcement of the law during the rest of the court proceedings to a final judgment. So we'll see what happens. I fully expect that the court will continue the temporary restraining order, enter a preliminary injunction, and the law will not be enforced until this thing goes all the way through the court system, however long that might happen to take. So
the expectation, just to be clear, most likely is that this thing is going to remain enjoined until potentially, if we get our day in court in the Supreme Court. I mean, I don't really think we expect even the Sixth Circuit to uphold,
right,
to go against the Supreme Court and uphold this law.
Right. Well, in fact, and we'll talk about it in a little bit, the Sixth Circuit, I think, on June 2nd, essentially quashed the state's argument on at least part of the bill. Now, for our listeners, let me explain that there are really three parts to the abortion law. The first part, the relatively easy part, I don't even know if the lawsuit sought to enjoin it, is maybe did, but but it deals with the ultrasound. The doctor needing to perform an ultrasound, advise the woman he's performed one, offer to show it to her and describe, if she doesn't see it, what it says. Now, that all sounds good, except that the Sixth Circuit recently ruled, with respect to Kentucky's law, is that the doctor can actually advise the woman, it's my medical judgment and advice that though I'm required to take this ultrasound and do certain other things, you should not let that be injected into your decision-making process, and you don't have to see the ultrasound or hear me describe anything. What would you like for me to do? So I don't know how effective that part of the law will be. I'm not saying you shouldn't pass it, but I'm not going to be surprised if Planned Parenthood doesn't put that in the waiver when you sign the form to have the abortion, that you understand you have a right to all this information and you're waiving the right to it. So it may prove to be of little help, to be honest. And the other thing that needs to be appreciated, that is not an abortion law kind of case. It is a case brought by the physician related to the physician's freedom of speech and being compelled to speak to women about what's, on an ultrasound. So that ultrasound portion of the law would never lead to really the reversal of Roe versus Wade. It's analyzed under the First Amendment.
Yeah, one's First Amendment, one's 14th Amendment. So
That's right.
Yeah.
That's right. Yeah. So abortion's 14th Amendment. Now, the other two parts of the law, and I think the one that the pro-life community had the most interest in was what's been dubbed the laddered portions of the bill that say you can't have an abortion if a fetal heartbeat is detected at 6 weeks, 8, 10 weeks, whatever it is, 12.
Yeah, I can't remember all the numbers.
Yeah, 10 of them. That's right. And each is divided by a separability clause that basically says, well, if we can't prohibit the abortion at the heartbeat, then that law, if that's unconstitutional, that's fine. But it doesn't affect the provision that says you can't have it at 6 weeks. And if that's unconstitutional, then that doesn't affect. We sever those provisions from the rest, and the next stage is 10 weeks. And if the court finds that's unconstitutional, the law says we'll sever heartbeat 6 weeks, 10 weeks from the law, and now we're going to look at 12 weeks, and so on up to 24 weeks. That's the second part of the bill. That's the part that would really get at Roe and Casey, supposedly, that most pro-life people really care about. Now, there's another part of the bill, the third part of the bill, dealt with what we call discrimination abortions. Those were abortions made because of the sex of the baby, the ethnicity of the baby, and if the baby has Down syndrome.
Yeah, there was a eugenics piece to that.
The thing the pro-life community needs to understand about this, and I was asked, actually part of the context for our discussion today, is after the Supreme Court held unconstitutional the law in Louisiana, the June Medical Services versus G, back in the end of June. The directors of some of the pregnancy resource centers were quite distraught. How could we lose? Roberts had just said 4 years earlier this kind of law was plenty constitutional, and now he says it's not. So I actually got asked to come speak to about 20 of the pregnancy resource directors from around the state, and so I'm sharing with our audience here some of what I shared with them to understand why we lost, and of course it was timely because we lost again in Monday in federal district court, and so anyway, there's the third part of the bill. So that's the discriminatory part. Now, as I explained to the women, that sounds really great and it's wonderful, and of course I don't think you should kill a baby because you wanted a girl and it's a boy. But I said, think about what real impact that has in the real world. How many abortion doctors are going to put in the medical record? I discussed with the woman the fact that she appeared to have a little girl and she wanted to have a boy. So we decided to do an abortion so she wouldn't have to have a boy. They're not going to put that in the record.
You're never going to see that in a medical record. No way.
Yeah. So how are you going to ever prove it? And then the second thing is about ethnicity. I mean, think about it. If I have sex with my wife and we get pregnant, which at this point would be a God intervening situation at our age. But if that were to happen, the odds are you're not going to go in and say, well, we really wanted to have a Chinese baby, and I don't understand. I didn't really want to.
You sort of know what the race is going to be going into.
Yeah. About the only time you would really be in a case of rape,
right?
Where you're raped by somebody of a different ethnicity, and then what's going to be the justification in the record? Oh, I didn't want to have a mixed race baby. It's
Right.
going to be I couldn't live with the consequences of rape and blah blah blah. So let's pat ourselves on the back. That looks great. Effectively, it doesn't.
There's just
do
no
very
way to
much.
really enforce this in a court of law.
Yeah, it's just hard. Yeah, that's right. So we're all really happy, and it's kind of like saying, "Yay, the Little Sisters of the Poor won," and then they're back in court the next day. It's like, yeah, that's a big win, wasn't it? Now we're back in court again. So that part of the bill, I hate to say, I never got real excited about. I know, one legislator in particular had a Down syndrome grandchild, and he obviously believes, as I do, that child is of great worth. But there was another legislator who had a child with another developmental disability, and it's kind of like, oh, so it's okay to have killed my child. Or it's okay to kill a healthy baby, just not one with Down syndrome. So we need.
I think that piece right there is one of the because again we mentioned that before, and that's the piece that's hard for me to wrap my head around the logic of what we're doing here, because that when we pass that's literally what we're doing in our abortion laws. When we pass a bill that says, it's against the law to kill a baby, to abort a baby with Down syndrome. Of course, from a principle standpoint, I agree with that statement.
Yeah.
But when you put those words into law and you put it into practice and you match it up with the other laws that are on the books, which you've effectively said is as long as it's prior to 20 weeks, you can abort and kill all the healthy babies you want, just not the ones with Down syndrome.
That's right.
I mean, and when you really dial it out and look at the function of what that law does, it's the dumbest law in the books. It makes no sense at all.
Yeah, it's we need to think about what we're communicating here. So the Attorney General, for instance, in his brief in response to the lawsuit, said, well, we're not prohibiting abortion, we're prohibiting discrimination in abortion. And
that's not our goal here. Our goal is not to prevent discrimination. Our goal is to prevent abortion, period.
Discriminating against live human beings who are born versus those who are alive but unborn.
Right, that kind of discrimination.
That discrimination we want to stop. So those are the parts of the bill. Now, for a little brief civics lesson here that many people don't understand, and I'll cover this quickly, but there are two things. Well, there's only one thing a court can do. It can, especially a federal court, well, all courts actually, is they exercise what's called the judicial power. We clearly know they don't exercise the executive power, and they don't exercise the legislative power. But the question is, what's the judicial power? So here's what the judicial power is, and got plenty of resources to back this up, and it's just true, that the judicial power is to enter a judgment resolving a dispute between particular parties. So this abortion clinic has a dispute with the governor over the abortion law, and the abortion clinic sues the governor, and the court resolves that dispute and enters a judgment. Now, it also issues an opinion that explains why it reached that conclusion and entered that judgment. As a matter of law, fact, and constitutional principle, opinions are not the legally operative means by which the judicial power is exercised. It's the judgment only.
Right.
That's all they do. They enter a judgment between parties to resolve a dispute between parties. In fact, the U.S. Constitution says that the federal courts only have authority over cases and controversies, and then they spell out the types of cases and controversies. Now, that's been clearly interpreted to mean, and rightfully so, that when you sue Kentucky over its fetal heartbeat bill, and the court says that fetal heartbeat bill is unconstitutional, it enters a judgment that says to the governor of Kentucky, you can't enforce the law. It issues an opinion that explains why. That is not legally operative, that judgment, against the Tennessee governor. It's just not. He's not a party to that lawsuit.
Yeah, he wasn't part of that case in controversy. Yeah,
he wasn't part of that case of controversy. The judicial power could not constitutionally extend to somebody who's not a party to the lawsuit.
Because they've not had their day in court.
That's right. It's a lack of due process.
Little thing called due process.
That's right. Now, the governor of Tennessee may well look at the opinion and say, wow, that opinion is really strong and I think it's right. And so if I enforce our law, I'll get sued, and I don't see any way around that opinion.
So maybe that's true.
Maybe that's the best thing to do.
Yeah.
But you look for ways to distinguish the opinion and the analysis of the court, or even to just say it's wrong. Now, there's nothing to keep the governor from saying that opinion is just wrong. So I'm going to enforce our law, and you're going to have to sue me too. Now, unfortunately, I have a letter from the Attorney General, from his Solicitor General, who believes in this concept of judicial supremacy, which actually says the judgment against Ohio is legally binding on Governor Governor Lee. I think I've been saying Haslam. Governor Lee. Well, that's just not true. It can't be. It's precedent, but it's not a judgment against him. Now, here's one of the things I said to the group the other day. When you think the Supreme Court is wrong, you can try to distinguish it. You can say, nobody raised this argument. Nobody raised this argument. So I'm going to now raise this argument and see what the court does. That's perfectly legitimate. That's not being obstructionist. It's not being heretical. It's doing your job. Now, the other thing is, a governor could say, your opinion is just wrong. And I don't think the other side argued it very well. So I'm going to enforce the law, and I can argue the case better than they did. So I gave a little example. I said there are two ways for me to have proposed to Linda. I could have said, Linda, right now you seem very attractive to me, and I like being seen in public places with you. Would you marry me? Wouldn't be real hopeful of that response, but I could have said, Linda, I can't imagine my life without you. You complete me. I think God has joined us together for his purposes, and I'd like to spend my life with you and getting to know you better and being known by you and to love you and learn how to love conditionally. Would you marry me? Now, odds are she's probably going to say, that's a pretty good argument, David. I think I'll marry you. See the difference? You can make good arguments and bad arguments. You can distinguish arguments. Yeah, the guy over here said, I just want to have sex with you and have you cook and wash my clothes. I'm not making that argument. I'm making a different argument. So we need to appreciate that. Okay? So anybody that tells you the Supreme Court's opinion is the supreme law of the land has bought into the lie of judicial supremacy.
Well, also, too,
Now,
the way I look at that sometimes is it's almost as if opinions are treated, the opinion is it's a necessary part of the process. It's the why. It helps us to understand, why the judge made this particular judgment. But oftentimes what's happening is we're treating opinions like something supplemental to the judgment. It's the judgment and the opinion. It's like it's
or the opinion becomes law.
Yeah,
and it's not law; it's an opinion about what the law is, but the opinion may be wrong. And in that case, the court is supposed to uphold the Constitution. The Supremacy Clause refers to the Constitution, not the opinions and holdings of the Supreme Court. Okay. Now, so we need to appreciate that. When somebody says the Supreme Court legalized something, they can't do that. They can prohibit the state from enforcing a law. They can't legalize anything. Okay? They don't make law in that sense. But now let's move on to the abortion decision and see how this is working itself
Well,
out.
just to make that clear, just to restate what you said, the court can take an existing law and declare it unconstitutional and make that law ineffective. But they can't
unenforceable. That's right.
Yeah, but they can't do anything after that to then replace that law. That's still the job. That's still a legislative function.
Right.
So this is a bad law. You can't enforce the law, but that's where the court's power ends. They can't do anything beyond that.
That's right. Now, they can award you damages, for example, if you've been in prison for some period of time, or the state took your property. They can do that. They can give you remedies, but they can't make a new law. Okay. And that's what happens a lot of times. The court essentially uses the concept of a remedy to make a new law. And because we believe in judicial supremacy, we just carry out the new law that the Supreme Court made without saying, no, you can't do that. But anyway, that's another story for another day. That relates to the same-sex marriage issue. But now let's look at what happened in court on Monday. So the abortion clinics sued the governor and those responsible for enforcing the law. And the state filed a brief in response to it. Now, for people to appreciate this, the first 8 pages of the state's argument focused exclusively on the discrimination parts of the law, the sex, the race, and the disability provisions. It didn't first say abortion is a bad thing, it's a wrong thing. It takes the life of another person who's entitled to life under the Constitution, and therefore we don't even have to get to the question of discriminatory abortions because we're discriminating against all natural persons who have a right to life. Instead, the argument was, let's defend the discrimination provisions first. Now, I understand that because that issue's not really fully been resolved. I think, in fact, there's a case in front of the Sixth Circuit where the court said, no, the discrimination bans would apply prior to viability, and you can't do that. And I believe there's now going to be an en banc argument over it, meaning all the judges of the Sixth Circuit are now going to listen and weigh in. So argue the low-hanging fruit. I don't have a problem with that. But like I say, I think the thing most pro-life people want to be able to say is this really a heartbeat bill? Or did you just, pull some shade over my eyes here that this is a heartbeat bill? Now, I'm not saying here the state is not going to defend it. The question is there any reasonable basis to believe that the court's going to uphold a prohibition after a heartbeat? Or that they will use that part of the bill to reverse Roe versus Wade? And I believe the answer to that is unequivocally no. This is not a heartbeat bill like what the House tried to pass a year ago, which simply said, once we discover a heartbeat, you can't have an abortion, period. End of the discussion. Now the state was trying to be wise.
Can I just be honest and say, am I wrong in saying, that was what, SB 1236?
36 was, yeah. The original version of it, yeah.
I mean, left with what we're left with today, would have been way better off just passing that bill as it was.
Yeah, I think so.
Instead of all of the steps now, if at least we would have just said, here's a heartbeat, there's a life, done with it. Hindsight 2020, wish we would have just passed that one.
Yeah.
Instead,
yeah. In hindsight, but anyway, so here's how the state is arguing what I would call the really main part of the law, and they're trying to do what I said they should do: distinguish the analysis of previous courts to say, well, you said we can't do it because of this, but I'm saying you can't do it because of this, and because of this. That's great. I appreciate that. Okay. But I want the pro-life community to understand what those arguments are. first argument is that this ban on abortion, even beginning at the heartbeat, presumably, is to prevent unnecessary fetal pain. So it doesn't say the life is valuable or that there's a right to life. It's just this is causes a lot of pain. Now the reality is the medical science there is quite uncertain. The 11th Circuit had a decision, I think it was in 2018. Supreme Court refused to hear it in 2019. And the 11th Circuit noted, we had experts on both sides who talked about when babies can feel fetal pain. But in the Alabama case, the state didn't really argue that point, so we're not going to talk about it. Okay. In June of this year, the 6th Circuit had a case involving Kentucky. Kentucky argued fetal pain. And the 6th Circuit said, no, you can't do that. It's prior to viability, which is somewhere around 22 weeks. So the state's trying to make an argument about fetal pain. And I would say right now, the odds are real strong. The 6th Circuit just ruled, 6 weeks ago, fetal pain is not a sufficient state interest to stop an abortion prior to viability.
To overcome that viability argument. Yeah.
Yeah, which is, because here's the point. If you're not a constitutional person or a person in which the state can have a legitimate interest, who cares? I mean, what Kentucky was dealing with in that statute that the 6th Circuit ruled on was a law that banned, admittedly it banned D&E abortions because it dismembered the baby. Those begin at about 15 weeks.
15 weeks.
The 6th Circuit said, I know you want to prevent fetal pain and all that stuff, and I'm not going to get into when there's fetal pain because you can't do anything prior to viability that puts an obstacle in the woman's way. And preventing her from having a D&E is an obstacle. It's an undue burden prior to viability. End of discussion.
Not allowing a doctor to rip a baby apart is creating an undue burden for the woman to get rid of her baby. Wow.
That's right.
What an argument.
Yeah.
It's also worth noting, as we're talking just specifically on the fetal pain issue, it was last year, right, in 2019, that Congress was looking at a fetal pain bill and it failed to pass. So this has failed in the courts. It's failed in Congress. It's failed everywhere we've turned.
Now, let me say what happened in June Medical here, because this goes to the difference between opinions and judgments. Judge Roberts agreed in the judgment. The thing that resolved the dispute between the abortion clinic in Louisiana, or abortion doctors, and the state of Louisiana. He said, law's not enforceable. He did not join in the opinion of the 4 other justices who supported the judgment. So see, that immediately makes it clear. Judgments and opinions are different things. If you wanted to say, what was the majority's opinion in June Medical versus G, I'd say there wasn't a majority opinion. There were 4, Breyer, that said this law is just bad, 4 who said this law is fine, and Judge Roberts who said, well, since Louisiana didn't actually challenge the undue burden standard. Now that's a quote. The state and the plaintiffs agree that KC is the appropriate standard. So therefore, I'm not going to address KC. I'm just going to say that a Louisiana law that's the same as the Texas law, if the Texas law is unconstitutional, then the Louisiana law must be unconstitutional too. Even though I disagreed, I lost. So I must be wrong, and I'm going to stick with what we said before. And how am I going to explain?
And you haven't brought me a new argument. You haven't brought a distinguished argument.
Yeah, that's right. You haven't really, and they tried to make factual distinctions. But he said, look, a law that says X and another law that says X, well, they're either both constitutional or they're both unconstitutional. And we said the first X was unconstitutional, so second X has to be unconstitutional too. End of discussion. Now, here's the unfortunate part. When the Attorney General, in his brief, gets to the laddered provisions of the bill, he says here, and let me just quote it so nobody accuses me of some inappropriate something or another. Let me look for it. He says, the state acknowledges, so we're acknowledging, that under Casey, a state may not prohibit any woman from, and it italicizes these words, making the ultimate decision to terminate her pregnancy before viability. We can't prohibit her from making that decision.
Dear Lord.
The next sentence says, however, the Supreme Court never considered the constitutionality of a law restricting the availability of abortion after a certain gestational age. And I was kind of like,
yes, it
okay,
is.
so I can't prohibit you from making a decision, but I can say that you can't make a decision after this period of time. That sounds like a prohibition on you making a decision. Well, no, I'm just saying the doctor can't do the abortion. Well, what good is my decision to have one if nobody can do it? I mean, I didn't get that. So I sent it to a couple of law professors, and they said it was a very clever argument to distinguish between the decision and the timing of the decision. And they said it was probably designed to get around a facial challenge so that the whole law wouldn't be struck down. And said, but even if you got past a facial challenge, when you get to an as-applied challenge, you've just killed yourself. You can't win. Because clearly when you say you can't have a doctor to perform an abortion after a heartbeat, that's an undue burden, right? So I think the state was probably trying to get the court to move past what's called a facial challenge to an as-applied challenge. Now, let me give our listeners just a little difference here. A facial challenge is a challenge that says the law on its face can never be constitutional. I mean, there's nobody it could apply to under any circumstance in which it would be constitutional. Okay? So, for example, if you said you can't have an abortion, period, if you're pregnant. Well, if that's an undue burden, it's an undue burden for everybody. And so the law, there's nobody that law could apply to where it might be constitutional, and everybody it would apply to, it's unconstitutional. So facially, you lose. Now, you could say the law says, for example, you can't prohibit an abortion if the reason for the abortion is the sex of the baby. Now, here's where that's important. The court could say, well, and this is what I think it said in Missouri, that prohibition seems to apply at any point during the pregnancy, pre and post viability. You can't discriminate on the basis of the sex of the baby. Now, prior to viability, I don't know. Is this really a ban on abortion, or is this a ban on discrimination? See that kind of argument? Now, after viability, maybe the state can prohibit it. So there's an applied challenge where you would say, this woman is pregnant now. She's 8 weeks pregnant, and she doesn't want to have a little girl. Does this law, as applied to her, is it unconstitutional? Might be as applied to her. If the woman was 24 weeks pregnant, the law might be able to be applied to her. So does that make sense to you, Gary?
Well, yeah, because in one sense, the baby has
That's
some
right.
sort of right. So the
That's right.
anti-discrimination laws kick in. But before viability, the law's already saying, well, this person
That's right.
has no constitutional rights, so our anti-discrimination laws wouldn't even apply at that point.
So the court in that case could say, well, you need to tell me more about the woman, because it's applied to a particular woman, the law might or might not be constitutional.
Right.
So my law professor said, by trying to distinguish between you can't have an abortion to saying, well, after these points, you can't make that decision. Well, that's a timing question. And he was trying to get past the whole law being struck down. Okay. And get into these severability clauses between, heartbeat, 6 weeks, 10 weeks, 8 weeks,
Right.
whatever it is. And that was the whole premise of the bill. Is I remember one of the sponsors of the bill saying the purpose is that at every stage of the gestation, the court's going to have to decide, is this constitutional? Okay, that part's unconstitutional. Now what's the next part? Now what's the next part? Judge Campbell blew all that off and said, I'm not going to sit here and go through this fetal stage by fetal stage.
And to his credit, nor should he.
No, not really, because that's a policy decision, and that's exactly what the Supreme Court said in 2016.
We don't want to hear these kinds of arguments. It's not
we
our
don't
job.
want to hear these separation cases where we have to go provision by provision. And I told the House Health Education Committee that very thing. I said, you're going to have to get past this too, not just the abortion idea, but the idea that severability clauses cannot shield your law from a facial challenge. So he blew right past that and said, look, this law prohibits abortions prior to viability. That's the end of the discussion. Now, I don't know, they may be able to convince him otherwise at the preliminary injunction hearing, and the court might say, okay, the only part of the law I'm going to hear is anything after viability. But the rest of the law, I'm going to preliminary enjoin, and then we'll debate 23 weeks and 24 weeks.
Which, in my very unprofessional opinion, is exactly where this is going to go, where everything else is going. I mean, the court has not upheld anything prior to viability in the entire country.
Yeah. So the Attorney General goes on and further admits again, these laws are subject to the undue burden standard. Now, here's what's interesting to me, and I'm quoting again. And the laws survive that standard, the undue burden standard, because they are reasonably related to a legitimate state interest, prohibiting fetal pain, protecting the life of the unborn. Women have psychological problems because of abortion, so therefore we should prohibit it. Those are all those distinguishing things they're arguing. That's our legitimate interest. Maternal health, fetal pain, life of the unborn. And, they say, they do not pose a substantial obstacle to abortion access. Now, if that's the only sentence you read, you might say, okay, yeah, we do have a legitimate state interest. I'm willing to go argue fetal pain and maternal health. It's psychologically bad for women. And the older, the further the pregnancy, the more psychological harm there is. And, there's the life of the baby too. And those are all legitimate interests. And these laws don't pose a substantial obstacle. Now, that being said, I'm going to read what the Sixth Circuit just said on June 6th with respect to Kentucky.
And we'll be closing on this point.
Okay. According to the Kentucky Secretary, the law serves the Commonwealth's interest in respecting the dignity of human life, preventing fetal pain, protecting the ethics and integrity of the medical community, so on and so forth. And it says, however, no Commonwealth interest may justify placing a substantial obstacle in the path of a woman seeking an abortion prior to viability, quoting from Casey. So you got all these interests, and maybe this law relates to, and it's reasonable to think it relates to these interests, but the Supreme Court has said you can't place a substantial obstacle prior to viability. End of the discussion. And when you can't have the abortion, in that case a D&E abortion, which is predominantly what you have after 15 weeks, well, that's a substantial obstacle. You can't have it. Don't give me arguments about, well, she could decide she wanted an abortion, she just can't get a doctor to do it. Or she could have an abortion by a different means or something. Well, there's not a different means at that point other than partial birth abortion. So the bottom line of this is that I think we have to expect to lose all the way up to the Sixth Circuit. And then we have to ask, is the Supreme Court going to be willing to hear this case? And I'd have to ask, why would they?
That's a great
especially
question.
where Roberts is.
And
Why would they?
and can I just say too that because you read our argument, I think you read the Attorney General's argument just a few statements ago, and he essentially. I'm just trying to wrap my head around this. We're in court to defend our state bill to limit and or ban abortions at particular stages, and we begin our argument by acknowledging that we cannot create an undue burden for a woman to have an abortion. Does that? I mean, right. just to me, in my just common sense, unlegal way of thinking, I would never go into an argument trying to prove something that I want to prove true by accepting the other person's premise as part of my argument. And that's the problem with where we find ourselves is
that's right.
We continue to pass these laws and we go into courts to defend the rights of the unborn. But in the defense of the rights of the unborn, we continue to acknowledge that the court has a right to protect a woman's supposed right to have an abortion without placing an undue burden on that right. That doesn't make any sense to me at all.
Yeah. Prior to viability.
Viability.
It's so if anybody thinks that that the way we're arguing this case could lead to the reversal of Casey and Roe, it's hard to argue the court is going to reverse when you've conceded that Casey is the right law.
Good law. Yeah.
Yeah.
Why would the court want to overturn something that you're acknowledging is a good and valid law?
That's right. And what did Roberts do just two Mondays ago? He said, well, you didn't argue Roe and Casey was bad law.
Exactly.
So you lose.
Exactly.
So, I just want pro-life community people to understand that until we're willing to tackle the tower, as Proverbs says, in which the stronghold in which the other side trusts,
pull it down.
We're not going to pull it down. And I'm hopeful that we can convince the Attorney General to make the Ninth Amendment argument and just say this is really wrong. The state has a right to protect the pre-political rights of all natural persons to life. Period. End of the discussion. And Roe was wrong, and Casey was wrong. And it's not because of fetal pain. It's not because of maternal health. And it's not because of discriminatory abortions. It's because it's wrong for the government to take away a God-given pre-political right.
Amen to that.
And, we may lose. But I think I've just explained to you, we're going to lose as it is.
Right. So just soon make a more constitutional argument than the same one that's been made over and over again and kept us where we are.
And lost. Yeah. So anyway, I hope listeners have found this helpful to understand the nature of the judicial power, how it works, and how it's being applied. The constitutional legal principles that are actually now being applied or not being applied in defense of our new law.
Amen to that. All right. Well, thanks again. And thank you all for joining us again today. Remember, you can send us your questions and concerns or comments to info@factn.org. That's FACTN.org. And we appreciate you joining us today. God bless. Bye-bye.
If you enjoyed this episode, don't forget to subscribe. And if you want to help spread the word, please give us a 5-star review and tell your friends to subscribe too. We're available on Apple Podcasts, Spotify, and wherever you listen to podcasts. God, Law, and Liberty is a podcast of the Family Action Council of Tennessee. We are a 100% supporter-funded nonprofit advocating for family, life, marriage, and religious liberty. For more information, please visit us at www.facttennessee.org. That's FACTennessee.org. And please follow us on Facebook, Twitter, and Instagram @FactTennessee.